working in various courts and tribunals across the country, and I'm based out of Bengaluru. As a brief, Disha Bharat is an NGO working in the field of value education since 2005, with the mission of nurturing values in the youth through holistic personality development, programs that complement formal education. Guided by the theme Know Yourself, Know Your Country, and Know Your Culture, Disha Bharat inspires young minds to discover their potential and contribute meaningfully towards nation building. Its annual flagship initiative, the My Bharat National Youth Campaign, is a 15-day movement observed from each year through the days of 1st to 15th August. Conceived in the year 2020 as a heartfelt resolve to dedicate the Independence Fortnight entirely to the Bharatiya cause. The campaign brings together students, educators, thought leaders, and citizens through inspiring talks, lectures, competitions, and multiple civic initiatives. This lecture series is of the larger campaign and seeks to instill the merits of patriotism, inspire responsible citizenship, and to encourage every young Indian to think of Bharata, speak for Bharata, and work for Bharata. In the same stead, on the eighth day in the series, we have with us Advocate Shri Kashyap N. Naik ji. It is our privilege to welcome Kashyap ji, a distinguished legal professional and the co-founder of Agra Legal at Bengaluru. G has an extensive experience in dispute resolution, corporate and commercial law, real estate, constitutional matters, and legal advisory. Kashyap ji has appeared before various courts, tribunals, and statutory forums across the nation. He has advised a wide range of national and multinational organizations, institutions, and individuals on complex legal and strategic matters. He also currently serves as a standing counsel for the Karnataka Power Corporation Limited and the News Broadcasters Association and Standards Authority in New Delhi. But beyond his legal practice, Kashyap ji has keenly an abiding interest in Indian literature, history, law, culture, and philosophy. A writer and a classical music enthusiast, he has also notably written on the works of Dr. Shathavadani R. Ganesh ji as well. We are delighted to have Kashyap ji with us today and certainly look forward to an enriching and above the most, a thought-provoking session. A very warm welcome to you, Kashyap ji. The session is now yours.
Thank you. Thank you, Manik ji. And I would like to thank Disha Bharat and the Mythic Society for having me here, inviting me to give this lecture. I deem it my privilege. And among all the notable members that you have had in the series of talks, I feel extremely privileged to be also joining them in speaking for My Bharat initiative of talks. Thank you very much. The topic for today is understanding democracy and constitution. Now, this is a very vast subject, of course, very difficult to cover within about 40 or 45 minutes, because as most of you all know, the subject of democracy itself has been extremely vast, especially in a country like India. And we have seen how importantly the aspect of democracy plays at not only every election, but even on day-to-day governance. And similarly, Constitution has had a great history. And starting from 1949, our Constitution has grown quite rapidly and has seen over 105, 107 amendments so far. And with all these amendments, we still continue to function under the same constitution. Several interpretations, misinterpretations of the constitutions have also taken place in our country, and there are numerous rulings of the Supreme Court as well as several high courts pertaining to the constitution. So to touch this subject itself is like trying to cover the ocean, which is very difficult. But what I would like to do in the session is only give a brief outlook and an overview on the entire subject of the democracy and the Constitution of India post Indian independence to the extent I have understood it so far. Now, when we look at the word or the terminology democracy, it comes from the Greek and Latin terms demo, which means mob. So, democracy is nothing but the rule of the people. So, there are several types of democracy. In India, what we practice is indirect democracy. So, in order to understand what is indirect democracy, let us first understand what is direct democracy. I'm given to understand that in this session, many students are also attending. So, to the benefit of some of the students, I may go to certain basic terminologies. Uh, Most of you may already know this, but for the sake of completion of the subject, I may only throw light on certain terminologies. Hope nobody minds it. So, direct democracy is one where on any particular subject or on any given law, the people directly get to vote and they decide what needs to be done. So, that is the case of direct democracy. The classic example of direct democracy in the history that we see is of the ancient Greek and Rome civilization, where every law or a rule, whenever it had to be put to enforcement and for its validation, the citizens of the entire Rome were called, or the entire Greek citizens were called upon to vote on every individual law, on every single new legislation that had to be enforced. And based on that enforcement, the if there was a majority of the public who would attend, and if they would vote in their favor, then it would become a law. So most of the Roman laws that we today are aware of, the Romans would go and vote for it. So therefore, it was essential for everyone to be proudly saying that I'm a citizen of Rome or I'm a Roman, because only those within the city of Rome would have had the right to vote for it, or the state of Rome would have the right to vote and make laws. So every individual, every citizen was therefore a legislator. So on any given subject, whenever a new law had to be made, everybody would be called, put to vote, and that's how the law would get enforced. The present day, if you could see any resolution, regulation that you would want to make, say, for example, you are living in an apartment, and in an apartment association, if you want to make a new resolution for the benefit of all the apartment owners, you have a annual general body meeting, you take out resolutions one by one, everybody votes for it, only then it becomes a law. So there again, there is a direct democracy. Indirect democracy is what India practices. Before we go to indirect democracy, we should see the folly of the direct democracy, especially not limited to minor institutions like certain societies or apartment associations or few other associations, but at a country at large. So we have the classic case of Socrates. So when for alleged misguiding of the youth, they wanted to know whether somebody could be hanged to death. It was the majority of the people who voted saying that Socrates is misguiding and therefore he should be hanged to death. So therefore, we see the folly of direct democracy, wherein it is not about what is just, what is right, what is conscionable, but what does the majority say. Based on what the majority says, the a law would be enforced or brought to force. That is the case of a direct democracy. Now, in order to ensure that democracy does not take into its hands, the majority do not take into its hands whatever it wants and try to do something illegal, unjust. Therefore, a system had to be put in place where we have something called as a rule of law. So whatever is just, what is conscionable, what is legal, what is justiciable, all of those had to rule us, not our mob mindset, not that most of us want something to happen, so therefore it shall happen. But most of us may want it, but whether it something is correct, what is just, only that should happen. That is rule of law. Now, this system where a rule of law governs the country and not just the majority is called as a republic. Therefore, you would see the preamble of our constitution, it says, we give it to ourselves to govern our country as a democratic republic. So, therefore, apart from democracy, it conjoins with the word republic, where we have a system of law in force. And based on the system of law in force, the majority will have to act. Now we come to the Indian scenario. In the Indian scenario, we have indirect democracy, where most people would go at the election, elect a political representative to vote on, to act on behalf of them. That elected representative goes and makes the law on your behalf. This is indirect democracy. So the philosophy of the elected representative or the indirect democracy in our country is that each member of the parliament or the member of legislative assembly understands the needs of his people whom he represents, and therefore his voice or his vote is counted. It may happen that a certain constituency may feel a particular way, but members of the other constituency may feel the other way. So therefore, overall, when all the members of the parliament do vote, the majority is therefore string. So this is the philosophy of indirect democracy. Now, to what extent is this practical or is it a myth? Now, we all see that even in indirect democracy, where the representatives of the people go and make laws, hardly have we seen, right from 1947 and where the first elections were held in 1950s, that the elected representatives on any given new law that has to come into force in the parliament or in the assembly have gone back to their constituency and asked the public as to what is your view on this particular law. So we have never seen the representative actually coming and speaking to the public and then going and casting his vote. So in to that extent, I must say that the participation of the people in direct lawmaking or the legislation is therefore more a myth. It's more in the philosophy than in practice. So whenever people say that democracy is a myth in India, they mean this, that they never have the right to say how a law needs to be legislated. They can be vocal about various laws, but ultimately it is the government that decides and the numbers speak for it. Again, when we have, uh, even to this day, the government's taking any action, irrespective of whether it was there in the manifesto or not, and what actions are they going to take on any given circumstances, we go by the numbers. So the very nature of going by numbers to decide on any particular subject is very essential to the feature of democracy. Now, in a representative democracy like India, although people do not have a direct approach on making of the laws, we have often seen that public movements have often tried to shift the manner in which a certain laws have been framed, have been withdrawn, have been redone, so on and so forth. To some of the youngsters who may be here, uh, very few years back, in the recent times, we saw that the central government tried to make farm laws, and there was widespread agitation. And to some extent, they withdrew those farm laws to come back to those laws with a lot of amended provisions in order to suit the public. So, therefore, what happens in our country post independence is that whenever a law needs to be relooked, there has to be some sort of a social movement, there has to be a political movement. And that is one of the main ways in which a law has been relooked. That is at least what the practice says. Now, there needs to be a fine balance between what the aspirations of the public is, whatever people would want to do, and what should be the extent of the long hand of law that would go and rule these very people whom who have elected a government. So this fine balance between what can the law be or what should be the rule of law vis-a-vis the people's aspirations has to be met by a sacrosanct document, and that sacrosanct document is the Constitution. Therefore, for a very fruitful democracy to be in place and to ensure that the democratic fabric of our country, the republic democratic fabric of our country, is woven very nicely in order to suit the aspirations of the public, the most important vehicle of progress of our country is the Constitution of India. So when we come to the Constitution embodies in itself certain philosophy, especially the Indian Constitution. We can say that the philosophy has three strands to it. The first strand is that it had to protect and enhance the national unity and integrity of our country. And number two, it establishes the institutions and the spirit of democracy. And number three, it fosters a social revolution to better the lot of the mass of Indians. So these three strands would have to be woven together, and that's how the constitution has come to place. How the constitution was made, how many people were there, how the constituent assembly debates went on, those are not the topic for the day today, because that's a separate subject in itself. So all we can say is, after much deliberation, we have seen that there is a constitution. Now, when we look at our Indian constitution, the salient feature is that it has two constitutions in itself. One is a constitution for the center, that is for the central government to function, how the entire Indian sovereign has to function in a particular way. So there is a constitution for it. And number two, we have a uniform constitution for all the states, irrespective of the number of states we may have including the number of union territories. It has to function in a uniform way. And that uniform constitution is also provided within our constitution. So it is two wedded into one. So at a very macroscopic level, if I can just point out what are there, what is the contents of our constitution. Our constitution deals with the union and its territory of India, and it deals with the subject of citizenship. Then it has the two main aspects of our constitution, that is fundamental right and directive principles of state policy. Then we have a separate part on union and a separate part of the states and a separate part on the union territories. Then we have a relationship between the union and states. And then we have a part on finance, property, contracts, and litigations or suits. That is also there. And then we have a part on trade and commerce. And then we have various services that are given under the unions and the states. Various services, when I say services, it has mostly governmental services which are given under union and the states. Then it has provisions pertaining to elections for both union and the state. Then there are emergency provisions, and then amendments. Amendment to the constitution is also a separate part. And then we have various schedules. Each schedule deals with separate things, one on languages, one on fields of legislation, so on and so forth. So this sums up as to what is contained in the Constitution of India. So what does Constitution basically do is that when majority people or the majority laws are trying to regulate or legislate on a particular subject, and the laws are going to change as per the societal needs, and new laws may be made, amendments may be made, certain basic things, fundamental things, which is essential for an individual to function, will have to be protected. So therefore, our constitution has one of the salient features of our constitution is part 3 of it, which is called as the fundamental rights. No matter what law may come over a period of time, certain rights are so fundamental to every human being that in the garb of majority acting or in the garb of the rule of law acting or any new law coming in, certain basic aspects of that is required in a human life for an individual cannot be taken away. These are called as the fundamental rights. Now, when we look at our constitution, we see that there are two things which are like two sides of the same coin. One is the fundamental right, and another is the directive principles of the state policy. What is the difference between fundamental right and directive principles of state policy? One is justiciable, another is non-justiciable. That is, if certain rights are given to you, which in case if it is violated either by executive action or by passing of any law, then challenging that particular action or the law. When I say law, it need not be only a statute, it can even be a government order, it can be a circular, it can be a notification, anything. So, by virtue of which, if some of these fundamental rights are breached or violated, you can go to the court and say that this is breached. So, therefore, I would want that this particular right be given to me, and hence quash this particular law, circular, or direct a particular authority to act otherwise, change the executive action. That is justiciable right, that is given under the fundamental right. There are various fundamental rights. So we have right to equality, we have right to life and personal liberty, we have the seven freedoms, freedom of speech and expression, freedom to assemble wherever required, freedom to move freely throughout the territory of India, freedom of your profession, occupation, or trade. So there are multiple freedoms. And then you have the freedom of uh, professing and practicing the religion of your choice. And certain minority rights are also given, and educational rights are also given. All of these were a bunch of rights were called as fundamental rights, which were put under Part 3. Any right which has been given under the fundamental right comes with a restriction which has to be again reasonable. So, in no freedom is unlimited. The freedom will have to have a check that is a reasonable restriction. And who decides what should be the check for any particular freedom? It is the legislators when they make a law that is being done. They do, they, by virtue of certain legislations or actions, they can restrict the freedom. Now, what are directive principles of state policy? The directive principles of state policy has again certain rights which are a guiding force for the government to function. It is like a flow chart given to the government to say that no matter which political party may come, no matter what your policies may be, but it shall generally be in this particular direction. So it is, I can give an example of, suppose you're traveling with a group of people in a very big bus where everybody gets to drive. And everybody, whenever the driver changes, he cannot change the very route at which the bus is supposed to reach. The goal will have to be the same, the destination will have to be the same. Of course, you will have certain freedoms of stopping whenever you want, going to whichever restaurant you want, so on and so forth. But the ultimate destination should not change. So, such ultimate destination are a bundle of governance rights, or the principles on which the governance should be made. Those are written in the directive principles of state policy. For example, they say right to livelihood is a directive principles of state policy. Right to work is a directive principle of state policy. Right to free education to everyone is a directive principle of state policy. That means that every government shall ensure that everybody gets to work. There is no unemployment. Everybody gets some livelihood. Everybody, there shall be no poverty in the country. In order to alleviate poverty, what should be done should be done. Everybody should have a shelter. So these are the governing principles for the country, for the government to function. That's why it is in the directive principles. But today I cannot go to court and say I'm jobless, I'm unemployed. Therefore, kindly direct the state, that is direct the state government or the employment. So that is called as a non-justiciable right, for which you cannot go to court. Directive principles of state policy. Now, how to make a fine balance on the curbing of the rights, the giving of the rights, what needs to be, what is reasonable, what is not. And as I explained earlier, even where the majority wants, can the rule of law snub the voice of the majority in the garb that it has the power? Or are there any restrictions for the same? a fine balance needs to be seen. Although Constitution does provide for it, the custodian of the Constitution is the court. That is where the judiciary comes in. Of course, we have all the three pillars of the democracy that they say legislature, executive, and the judiciary. But the custodian of the Constitution has the work of that or the responsibility of that has been given to judiciary. So judiciary in India has dual role. One is to adjudicate the disputes between two private parties whenever there is a dispute. There, the constitution has nothing to say. It is only about, it can be a property dispute, it can be a commercial, contractual dispute, or anything else. So it is a dispute between two individuals or two concerns. But where the dispute becomes between the government or state action and an individual, or a particular law that is infringing upon the rights of an individual, there it is the constitutional right that gets violated. So in order to ensure that these rights are saved and the rule of law, even in the garb of making a particular law, if that law is violating the individual right or a particular person or a set of persons, group of persons, then the courts will have to law is invalid. Now, this is a special feature of our constitution. If we just take the history of our constitution, we know, I mean, most of the law students, of course, know this, that the Constitution of India was basically a makeover of the earlier legislation, which was the Government of India Act 1935. The Government of India Act 1935 was made by the British, and that already had the two houses, the member of the council and the legislative assembly. It had the Westminster model. It had elections, free and fair elections. Most of this that we see, some of these were already there under the Government of India Act 1935. The Indian Constitution, as far as the governing aspects were concerned on the parliamentary, executive, courts, etc., it continued with whatever was there under the Government of India Act. But certain fresh provisions pertaining to fundamental right, citizenship, directive principles, these were later borrowed from various other constitutions. Our constitutions were studied from various constitutions, and some of these provisions were inserted into our constitution. So therefore, the court, whenever there is a dispute on a particular law infringing upon or impinging upon the rights which has been guaranteed to us under the constitution, or even if a majority of the public want a particular law, but a certain law is not giving the option of the voice of the majority, in all such circumstances, the constitutional courts are going to intervene. Now, there are only two constitutional courts. One is the Supreme Court and another is the High Court of every state. So wherever state can act and do certain things, you can challenge these actions. I was mentioning about the Government of India Act. In the Britain, there is an unwritten constitution. They don't have a written constitution at all. So a set of constitutional principles which has come forth over a period of time by the precedentary and customary laws have now been called upon as the constitutional laws. There, any law made by the parliament can never be challenged. So they still go by the old rule of the king can make no mistake. Whichever has been passed by the British Parliament, such laws can never be challenged in the court as unconstitutional. It is at the wisdom of the Parliament of Britain itself to change what law it has and thereafter govern themselves. However, in India, there has often been a discussion of who is more supreme, Parliament or judiciary. The answer is quite clear. Neither of them is supreme. It is the Constitution that is supreme. So therefore, whenever any particular law, even those laws which have been made by the Parliament gets questioned, it has to be seen in the touchstone of Constitution. And if it violates the Constitution, that law will have to give way. It has to be nullified. So that is the speciality of our Constitution. Now, let me give very few examples on where the democracy or the Constitution was also at threat, considering that I do not have too much of time, the illustrations will also be quite minimal. So many of you are aware of the emergency that was declared in 1975 and what led to it. But before that, before even the emergency came into picture, there was a case called Keshwanand Bharati versus State of Kerala. What had happened by then was that the Indira Gandhi government, which from 1967 onwards, made a series of legislations and brought in various laws in the name of public policy or few other governing aspects which tried to impinge on the fundamental rights. So earlier there was, long back, there was a judgment in 1950s called as the IC Golaknath case in 1960s. The Supreme Court had said in the IC Golaknath case that the parliament can never amend anything in the fundamental right. It has no right to amend the fundamental right because it is very fundamental to everybody. It can't be taken away. Thereafter, there was nationalization of over 14 banks that had taken place. The nationalization of banks were challenged in the case of R.C. Cooper versus Union of India. And the bank nationalization law were declared as unconstitutional. It said it violates fundamental rights, Article 1914, and therefore that was set aside. After bank nationalization, the government again tried to remove the privy purse which was granted. Privy purse was various princely states when it had to accede to the Union of India and become part of it. Because as many of you know, there were as nearly 565 princely states in India when India became independent. India was not given independence with only two nations as India and Pakistan. When British left India, Pakistan was formed, but several princely states were given the option of either joining Pakistan or India or continue to be independent. So it was left in the lurch. So all those princely states acceded itself to the Union of India and they became the last two states being Hyderabad and Kashmir. And when all of them came into the Indian accession, there was a contract signed between each of those individual rulers or the kingdom or the states of, say, for example, state of Mysore and India and so on and so forth, where they had certain terms on which we will come. And they were promised that because your revenue, your economy is going to be taken away by the state will pay you X amount of money. That X amount of money was called as privy purse. That was abolished in the 1960s. The privy purse abolition was challenged, and the Supreme Court held that this was unconstitutional and again set the rule of law. And they said that you cannot amend the constitution and say, I'm going to take away your privy purse. So with all of these setbacks to the Indira Gandhi government in the 1970s, what they tried to do is they tried to amend the amending part of the constitution itself. They said what can be amended, what need not be amended. So they said that majorly there were 24th and 25th Amendment Bill of the Constitution were passed. There they said under Article 13, that is the very first article of the fundamental right, that defines what a law is. And they said that definition of law, where it says fundamental, any law that impinges on the fundamental right can be declared as unconstitutional. They said that law does not include amendment to constitution. Any other law can be challenged as fundamental violation of violative of fundamental right. But if I make a constitutional amendment, you cannot say that can also be violative of fundamental right because we are exactly what we're trying to change. So that was the first amendment. Second, they said by then there was property rights. There were most of the disputes till then which had gone to the Supreme Court, and most of the constitutional judgments till then were mostly on the right to property. So they said before that Article 368, which gives the amending power to the Parliament to amend the Constitution, they said whenever the Prime Minister and the Cabinet Ministers say that this is the amendment that we would want to do, that is the Cabinet along with the legislature, when they pass a bill and it goes, the President does not have an option to say, no, I will not give. He shall give consent or assent to the constitutional amendment. This was the change made to the amending power itself. Then they said, whenever property is taken away, see, what did the government do in bank nationalization? They basically took away, they nationalized the bank. Before that, they had nationalized the insurance companies. So most of the insurance companies which were privately made, the government took it over and they said, this is ours now. What we need to see is, until then, there has been no instance of the government running a particular industry well. Insurance was never started and run by the government well. The banks were never started and run by the government well. These were all private people, private institutions, which ran the business and which control. So they started controlling by virtue of this. So all of them were going and they said, when you are trying to take away my property, you need to compensate me for whatever is the loss. So they made an amendment and they said, when I compensate you, I don't have to the word compensation means whatever is the loss cost, that particular loss will have to be repaid. That is compensation. So they changed the word compensation to an amount. That means I don't have to pay your actual loss, but I can pay you something. That is an amount. That was one of the amendment. Then they said, whenever I make a law which is in furtherance of directive principles of state policy, then you cannot challenge that particular law as being violative of fundamental right. So in order to say that everybody should have right to work, if I take away some of the jobs which are already existing in few people, or if I take away the salaries of few people and give it to somebody else, it is a law in furtherance of directive principles of state policy. Such law was never made, but that is the effect of it. If any law is made in furtherance of directive principles of state policy, then you cannot go to the court and say fundamental rights will be violated. So the courts will not have any option to say that such a law is unconstitutional. This was amendments made to the constitution. So these were challenged in the case of Keshwanand Bharati versus State of Kerala. There were 13 judges in the Supreme Court at that point of time. All the 13 judges passed the judgment. Of course, it was not unanimous. It came on a ratio of 7:6. 7 judges decided in one way and the 6 judges decided the other way. And the earlier judgment of I.C. Golaknath, which said that fundamental rights can never be amended, was also called in question. Because I.C. Golaknath was made by 11 judges, they said 13 judges will sit to overrule I.C. Golaknath. Therefore, more number of judges had to sit here. In Keshwanand Bharati versus State of Kerala, the Supreme Court, through the 13 judges, made a new doctrine called as the basic structure doctrine. So they said, of course, the parliament has the power to amend the constitution, because as and how society changes, you may have to change the constitution as well. That amending power has been given in the constitution itself under Article 368. You can do it. But when you amend that constitution, certain things can never be amended, which is very, very basic. These are not only fundamental rights, even fundamental rights could be amended. But there are certain basic elements of the constitution which can never be amended. So there came a doctrine called as the basic structure doctrine. This is the manner in which our constitution has traveled. So in independent India, how has constitution been? In order to answer that, I'm saying this particular judgment. So what is the basic structure? Each judge had his own view of what is the basic structure, but ultimately we can say the supremacy of the constitution. It is not the parliament or the any of the organs that are supreme, the constitution is supreme. That was, everybody held that to be the basic structure of the constitution. So rule of law shall always remain. Number 2, republican and democratic forms of the government. That is a basic structure. They said secular and federal character of the constitution is a basic structure. So we can never make the constitution to be tomorrow, say, belonging to only one religion and the other religion shall subserve the other religion. This cannot be. Then separation of powers between the legislature, executive and judiciary is a basic structure of the constitution. Then dignity of the individual secured by various freedoms and some of the fundamental rights were declared as basic structure of the constitution. Now, the democracy, unity, nobody questioned this. But under the fundamental rights, they said the right to property is not a fundamental right. So except that most of the other rights were fundamental rights, it had to be taken care of. After the basic structure theory was passed, this was again a setback to the government because whatever they tried to change in the constitution was ultimately not being able to, and some of their amendments were struck down. By then, Raj Narayan had challenged the election of Indira Gandhi, and that had run in the Allahabad High Court for quite some time. There were 352 MPs in support of Congress at that point of time. And election of Indira Gandhi was set aside as illegal by the Allahabad High Court in the election petition, and they said that there were certain corrupt practices made, and therefore the election of Indira Gandhi is set aside. Now, out of 352 people, if one person's election has been set aside, there were still 351 other MPs. They could have elected one more other member of parliament and said he or she will be the prime minister. They could have run. But Indira Gandhi said, no, I'm going to declare internal emergency. And the moment there was a emergency provision was invoked, why was the emergency provision firstly kept in the constitution? See, our framers already had seen in the history that many a times the history of India, if you look at how the kingdoms and rulers have behaved, whenever there has been a foreign aggression, the entire country has never fought as one. Whenever there was foreign aggression, we had seen that one or the other two states becomes friends with the enemy. They try to catapult the main leading ruler, and they get certain other rulership here, and they get some purses or a part of the kingdom, and they get to rule. So this the Indian history had taught us. So the emergency provision was an important provision which was inserted in the constitution to say that when there is a foreign aggression, whenever there is even an internal aggression, which mandates that the states would wither away, or you may go with the enemy state tomorrow and say that I'm going to be part of it. Say, for example, way back in 1980s, 90s, or early 2000s, we know the situation of Kashmir. If there was an aggression from Pakistan and suppose certain areas of Kashmir, they said, we are going to side with Pakistan, from now on we'll leave Pakistan, what would happen? And the government there also made a law saying that we are going to accede with Pakistan, what would happen to our country? They said in such manner, in such times, either internal or external, there can be an emergency provision when invoked, the entire country loses its governance. The individual states loses its governing capacity for the single governance of the union government. And the union government, because of that external or internal emergency, can act as one single force and ensure that that aggression is quenched. Therefore, it was an important provision. But this was misused in 1975, and they cited internal emergency, and they started with a whole lot of things. I mean, I don't have to get into details of what happened in the emergency. Now, this was a classic case where, although the majority wanted, the reason I cited emergency is because although the majority never wanted, there was no aggression in the first place. The majority people in the country never felt that there was anything, either internal or an external disturbance, that really needed them to go succumb to a particular authority and they could wield the power they wanted to. But still, just by misusing the powers under the constitution, the rule of law, the hammer of the rule of law came, thwarting every democratic voice that was available in the country at that point of time. And we know the history, then what happened, and until the entire parliament, the emergency was in rule, nobody could do anything. And thereafter, there was a change in power after the election, and the Janata Party was voted to power. Now, in the midst, even when most of the opposition party MPs were put in jail and there was nothing going on in the parliament as a constructive debate or opposition on the other side, the then government of Indira Gandhi made en masse amendments to the constitution, which they changed the very nature of our constitution. Several provisions of the constitutions were amended. These changes in the constitution challenged before the Supreme Court. Ultimately, in the case of Minerva Mills case, the Supreme Court negatived most of the amendments made by then, and they said that you cannot make these amendments and change the constitution the way you want because it violates the basic structure theory, and they nullified those amendments. Of course, the Janata Party also nullified a few amendments by bringing in lot of constitutional amendments to redo whatever uh, damage was done by the Indira Gandhi government earlier. And so we see with that classic example of whenever there has been even majority people wanting something else, the government has tried to act, but the constitution has saved us. And we have in our even in our ancient text itself that dharmo rakshati rakshitaha. What does that mean? That if you protect dharma, dharma will protect you. Similarly, constitution by itself will never come and protect anybody else. It is the job of every Indian to ensure that the constitution is well protected. And if it is well protected, the constitution will certainly protect everyone. And we have seen instances in our country, what has happened so far. And I think I have completed 45 minutes. With this, I can only say that an overview of the functioning of how the voices in the democracy have at times tried to raise, and how the rule of law has tried to either pour water into it or snub it, and how the constitution becomes an important document for the functioning of the governance of the country. Of course, this gives rise to various doubts. This gives rise to various discussion, debates, and so on and so forth. This has been happening on and on. But all I can say is that sheer majority rule by itself is never a problem. In fact, for an effective governance, you do need a majority rule. Those who are well acquainted with the political system of India after the collapse of the Rajiv Gandhi government, that is in 1992 onwards, almost until 2014, we saw that there was always a coalition government which seriously hampered the progress of the nation. So it's always necessary that a majority government should be in place. But unless the majority government does something which subverts the very rule of law, the majority government should always have the voice to do what it wants. Now, there is a small distinction, with that I will end, that many a times it is often seen that the court's ruling, why are they interfering, so on and so forth. There is something called as public policy. There are certain policy matters which the government alone will decide. The courts have no role to play in it. There are certain matters where it is not policy matters of the governance, but it relates to innate rights of certain individuals. Unless and until certain innate rights of the individuals are affected, the government generally should do what it wants. And the presumption in law is that the government understands the needs of its people and it is doing it. But however, if it tries to impinges upon certain fundamental rights, the courts will have to safeguard it. Has the court not traveled beyond its scope and tried to get into matters which it should not have? Yes, it has. We have seen several times that the court has transgressed its domain, tried to get into judgments on certain aspects which it should not have. But for that, again, the parliament will have to come in quite strongly and say that this is where your limit is and this is where we need to do. We have also seen that political will is also extremely important. There are at times where, for lack of political will, the political parties hide under the skirts of the court and wants the court to pass judgments on certain matters. And therefore, you are feeding the court to pass judgments on matters which a political will is supposed to take place. And when court does it, it also assumes a certain power and responsibilities and says, I can do anything I want on various other subjects. So a fine balance will have to be run. Now, in order to ensure that both parliament, executive, and the judiciary run on the fine balance that it is supposed to run, and the supremacy of the constitution is maintained, the answer as to how it should be maintained lies with every single citizen of the country. So it is the duty of every single citizen, as the great legal luminary Nani Palkiwala had put it, that constitution is a dynamic organism which continues to change with the societal needs changing. And unless a vigilant Indian is present, this the protection of the constitution can't be only trusted with one of the organs of the state. Now, I go back to much earlier before the constitution was even framed. The great polymath, scholar, poet of our Karnataka, Dr. D.V. Gundappa, in one of his earlier writings, had clearly noted that the pillars of the democracy is not just the three organs that are running or the media. It is also important that an informed citizenry is extremely important to run the country, because the laws may be various, it may impinge on a right, may not impinge on a right, but the citizen should be informed well of what is happening, and there should be continuous discussions in the place. So several institutions will have to be born in order to ensure that people are educated time and again. To that extent, D.V. Gundappa started Gokhale Institute of Public Affairs, and in that name, he ensured that people are generally educated on all political, public, not political, but public and economic financial matters. And he ran that institution as an example. And I'm glad that institutions like Disha Bharat, Mythic Society are also taking similar step of making an informed citizenry so through various initiatives such as the present one. And I only hope that more such forums comes into play, and most part of our countrymen are well aware of what is happening, and rights people speak in it, and they are more informed to take collective decisions. Thank you.
Thank you so much for such an informative session. We just have a short Q&A, a question answer session. We have some few questions we'd like to throw at you, sir. So the first one being that India as a democracy, as a nation, both as the way it started, it gave every adult the right to vote from its very inception. Far back at a time when much older democracies took over a century to get there. So, what do you think made our constitutional framers and society think in that manner?
Yeah, the answer to that also lies a bit in the history. Much before the constitution was framed, under the constitutional law, there were three legislations. The Government of India Act 1909, which came after the Minto-Morley reforms. The Government of India Act 1919, which came on the Montego-Chelfam reforms. And then the 1935 Government of India Act. All these three acts, in one or the other way, gave only certain people in India the right to vote. So unless you are a member belonging to so and so, only in many places women could not vote, only men could vote. And a person having a particular education qualification alone could vote. So starting from 1909 until the framing of the constitution, there was uh, voting rights being given, but that had seriously curtailed rights to Indians, especially to rural Indians, who were the majority of the masses. It had curtailed voting rights to women. So what our constitution framers have thought it fit is that every Indian by 18 is supposed to have been to some extent educated. And by 18, they said, of course, there was a lot of discussion in the Constituent Assembly debate on what should be the age. Let us not get in there. But the idea was that every Indian should have a right to say on who should be forming the government. So with that basic idea, and having seen how it had happened from 1909, because there were elections earlier to that also, to the representative assemblies. So they said everybody should have a right, and hence the right to vote was given right from the inception. And when you talk about other countries trying to get there, no country took long time after the half of 19th century. I mean, when you see history, you see it as a whole. So when you talk of, say, European, some of the European countries or Australia, when they started giving rights, their right to vote also evolved over a period of a few centuries. In India also it evolved. So what it was in 1857 to what it was later in the 1850s or 1950s was altogether different. So that way it was given. Sorry, you are on mute. I can't hear you.
Sorry, sir. So, the second question is also quite interesting in that fact that many people don't have much idea about is that the original constitution was handwritten and it was illustrated by Sri Nandalal Bose and his students with scenes from the Ramayana, Buddha's life, Vikramaditya's court, Chhatrapati Shivaji's life, and even some portions of the Dandi March. So, what do you think the constitutional framers were trying to set forth and convey through this imagery?
Well, the imagery, I mean, it evoked a sense of emotion in them, is what I can say. Because whatever they had to write was in black and white. The images were more added as an emotive measure to the constitution. Back then, reciting the Ramayana or seeing the images of Shivaji or anything else was not considered to be Hindutva or not considered to be belonging to one religion, or this was not secular, because the word secularism had a very plain meaning, the English meaning, not the pseudo secularism meaning that we later saw. So therefore, uh, by by seeing these images, I can only say that everybody took it in the right spirit. They were more secular.
Right, sir. Uh, Another question is that what we've usually seen is that fundamental rights almost always get all the attention in constitutional discussions or matters. But fundamental duties are barely discussed. So I wish to understand, why do the duties matter and what would change if society actually took them seriously? Also, in light of your suggestion of having an informed citizenry.
Well, the fundamental duties was never part of the constitution in the first place. When the constitution was initially framed, we don't see fundamental duties at all. It is a chapter 4A which was inserted later. And if you look at the fundamental duty, respecting national anthem, respecting national flag, respecting the leaders, uh, I mean, this would come out of you generally, but in effect are not actually duties of a citizen that is required in a healthy, welfare, democratic society per se. They wanted to have fundament. The for a law student, we all know that the two sides of the coin are fundamental rights and directive principles. Fundamental, I mean, as a high school or a primary student, you would often learn fundamental right, fundamental duty are same sides of a coin. It is important. What should be fundamental duty? I mean, the legal discussion, as you grow, you know that this is to my see the violation or non-action of a fundamental duty does not give rise to any penal offense in the first case. So, as good as how a directive principle of state policy stays there without the government may not actually do something on it, similarly is the fundamental duty, I must say. But having said that, the one of the major criticism to our constitution, when one of the first persons to criticize our constitution through a very scholarly work was Mahamahopadhyaya Pandurang Vaman Kane, Bharat Ratna P.V. Kane. He wrote a 8-volume treatise on the history of Dharmashastra. And on the last volume, there is a separate chapter dedicated to criticism of our constitution. And one of the first major criticism that he says is that our constitution is more rights conscious, it is not duty conscious. The answer to your question also lies in how the Dharma Shastras, earlier one, the earlier Dharma Shastras not only concentrated on the rights of the society, it also concentrated on the duties of the society. They spoke much on what needs to be done. It was prescriptive and prohibitive in nature, restrictive in nature. But if you look at the present day laws, it does not prescribe on what you are supposed to do. It only restricts you on what you should not do. It lets you free. It lets you do what you want. So therefore, other set of the criticism to constitution was that the constitution of India could have been the constitution of any country. What is so innately Indian about the constitution? So if you read our constitution, what is the Indianness that you find in the constitution? So the one of the members of the Constituent Assembly debates, Sri K. Hanumantaya, once had very famously remarked, uh, we wanted the music of the Veena, but we have the music of the English band in our constitution. So these are criticisms to our constitution. And these were, of course, debated. They were debated that, why don't we put several provisions pertaining to this? But it was negatived at that point of time. And we must know that no matter what, every person is a product of his time. And so also the constitution makers were a product of their time. So when they did make the constitution way back in from 1946 to 49, the liberalism, federalism, uh, equality, these concepts which had occupied the minds of Westerners had also occupied our mind. And in one of the episodes that DVG writes, he says that when he met one of the persons who was part of the Constituent Assembly debates, he said, you have been reading a lot on the English literature on liberalism, equality. Why also you not look into some of the aspects of Dharma Shastra, which where some of these Rajya Shastra elements are also mentioned quite in detail? He said, no, these were all times of the old. We don't have to really look into it. And they turned their way out. So the it is always, no matter many visionaries wrote it, there is always a reactionary element or a tinge or a flavor of reactionary that is attached to our constitution as well.
Gee, but I mean, considering the fact that you said that, changing times requires change and hence the amendable nature of the constitution as well. But the constitution in toto has been amended over 100 times or more. And yet its basic structure is held to be beyond amendment. So, how would you explain that balance to a layman? And what's your view on its unamendable nature?
Constitution is not unamendable. It is, of course, amendable. And if you look at the basic structure, you tell me what you want that you change in the constitution that the constitution does not provide. And the other good aspect is that the basic structure also can evolve over a period of time. The basic structure doctrine did not say that these articles cannot be amended. They never went into that. They never said that a particular wording should not be amended. The basic structure doctrine only says that constitution shall be supreme. I mean, whatever you would want to change in the society, I don't think tomorrow you would want to say that constitution should not be supreme. What you want in the constitution may change, but the constitution shall have to be supreme. I don't see a problem with that. And the federal nature, that is, tomorrow no government should tomorrow come and say that there shall be no states in India at all. Everything will only be, like the Ekachhatradipatya, only I will run it over a period of time. You need regional voices and you also need a national voice. Both are not opposed to each other. The fact that I'm a Bangalorean, the fact that I belong to Karnataka are not in any way opposed to each other. Similarly, I speak Kannada does not mean that I hate Telugu. And the fact that I'm an Indian does not anyway belittle my regional rights or my representation over my state or a city. So they are not in any way opposed to each other. So the right interpretation is what is required for the basic structure. So therefore, I don't think the basic structure is coming in the way of any proposed amendment that anybody would want to do to the constitution, unless and until they want to change the very thing. But of course, see, one example I can say. For example, one of my friends, Mr. Vasant Kumar from Chennai, he has filed a petition in the Supreme Court asking the Supreme Court to, direct the union government to have a national court of appeal over the High Court, where they say that on High Court, that today the Supreme Court is deciding on property issues, on defamation, any dispute can be taken to the Supreme Court. The sanctity of the Supreme Court is taken away. So they said have a separate court of appeal where every appeal can go up till Supreme Court. They can decide what they should not, but only questions of extremely national importance alone should be kept at Supreme Court. Now this is a petition which is pending. Whether the government will do, whether the judiciary will agree, it's a topic for another day. But such an amendment can be allowed. Now, the three organs of the state is not a basic, I mean, although it is demarcation of power between the three is a basic structure of the constitution. If you want to amend it to say that I'll add one more court between Supreme Court and High Court by amending a few articles, it will not take away your basic structure. It will continue to remain. So that's a classic example to say that whatever amount amendments that you propose, the basic structure doctrine is actually not coming in the way.
Right, so it's a very interesting point of view. We're going to, just before we conclude, we have two more questions. So, one being that institutions like the judiciary, the election commission, and the like are considered to be like torchbearers or the torch-bearing machineries that keeps a democracy honest or democracy in tandem with its democratic nature. To an average Indian, how does that machinery actually work day by day?
See, it doesn't work on a day-to-day basis, to be very precise, because the job of election commission is to hold free and fair elections, and its job ends by giving the result out. The job of election commission is to ensure that when it has two jobs. One is to ensure that whoever is entitled to vote shall be given the option of voting, and they should also be informed of their right to vote so that people come out in large number and vote. That is the first job of the election commission. And number two, fairness and transparency in the holding of that particular office of election commission. And once they complete their job and the result is out, the government will have to run on a day-to-day basis. So if you ask me who runs on a day-to-day basis, it is the executive which is running the country on a day-to-day basis. Now, the second is the judiciary that you asked. Judiciary on its own has hardly come to impinge on somebody's rights or try to say something. Unless and until somebody knocks on the doors of the court hardly opens its mouth. And the judiciary need not have its own view. And the only view of judiciary should be available is only through its judgments. And some judgments are welcome, some judgments are criticized. And if you ask me, has the judiciary not passed any wrong judgments? It has. Even on constitutional matters, it has. It has been severely criticized. But again, that is how an institution should be. I mean, you can't say that the institution should not make any mistake. But the institution, whenever it makes a mistake, should be able to correct its mistake. So therefore, we have seen several judgments of the Supreme Court where they have overturned their own judgments earlier. They have tried to set the law later. So, for example, say the famous habeas corpus case, it was a wrong judgment of the Supreme Court. The entire country way back then said that the habeas corpus case was a wrong judgment. The dissenting opinion of Justice Khanna was the right opinion, because in that case, they wrongly held that whenever there was an emergency declaration, nobody has the right to life. That's how they interpreted the Constitution. They said their life can be taken away by the government. Somebody can be shot, and they're not answerable because of an emergency provision. This was a very wrong interpretation of the Constitution. But of course, everybody criticized it, and 30, 40 years later, the judgment was also overruled. So we have several instances like this where some of the constitutional judgments have also taken its turn. They have tried to correct itself and they have come forward.
Right, so I think it would be safe to say that every institution at the end of the day is just a body of human individuals and you're allowed to err and correct yourself and so on and so forth. So, as a final question, um, what would be the one habit, practice, or a value that you would recommend to a young Indian who wants to be a genuinely responsible citizen and not just a mere voter in today's society, or like a takeaway message that you have for the youth of this nation?
Don't be influenced by social media, and don't think that newspaper articles or the blogs that you see are scholarly enough to educate you. And don't be driven away by so much of by either of the political parties, in any kind of political parties trying to set a narrative. And today, with the help of so much of media presence in everybody's life, the narrative building has been immense. So therefore, the need to look within and understand it, dig deeper, and see a bit of history, learn, and then come back and make your rational opinion is the fundamental duty of every young Indian who wants to participate in the democracy. And we have seen that in our country, the last few hours, the last few days of the election generally space the result. And it's sad but true. That's what has happening. So when we say informed citizenry, the information doesn't come, the opinion doesn't evolve in a few hours or a few days or a few news reports. It has to evolve by a detailed knowledge, which can happen by continuous reading, understanding, debating, and uh, keeping your mind sharp on political affairs, but not being involved in it.
Right. So I gather that a rationally nationalistic discourse is what is required in today's society. Uh, and in conclusion, I would like to conclude this wonderful session by giving out my sincere thanks to Shri Kashyap Naik ji for making time and sharing his views and, of course, his thought pondering ideas with us. I thank Disha Bharat for creating this space and persistently conducting the annual lecture series through the My Bharat campaign. I thank all our dear viewers for spending their valuable evening with us. And last but not the least, this beautiful land of Bharat for nourishing us throughout life. Before we end this live session, I'd just like to update the audience on what we have scheduled for tomorrow under this lecture series as displayed here. So it would be day 10 of the My Bharat series, which has two portions, one being a life sketch of an individual, and the next on the responsibility of social media, which also acts as an annexure to what Kashyap ji just suggested that youth need to be careful about. So my pranams, dhanyavad, thank you, and Jai Hind.
Thank you. Thank you for giving me the opportunity. Thank you all.
Tomorrow evening, sharp at 7 p.m., a talk on Vande Mataram, 150 years of inspiration, unity, and national pride. The speaker is going to be Shri J. Nandakumar, Akhil Bharatiya Sanyojak, Pragna Prava, New Delhi. Please join in large numbers and support. Thank you. Namaste. Jai Hind.
Jai, dhanyavad.
Thank you. Jai Hind.
ಕಶ್ಯಪ್ ಸರ್ ನಮಸ್ತೆ. ತುಂಬಾ ಧನ್ಯವಾದಗಳು. ನೀವು ದಿಶಾ ಭಾರತ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಬಂದು ಜಾಯ್ನ್ ಆಗಿ ಮಾತಾಡಿದ್ರಿ.